I have been teaching lawyers how to draft for about the last 25, maybe 30 years. And for years, we taught lawyers how to draft. Now, how to write is the easy part. Most lawyers, I mean, you're university graduates, you know how to write, you know how to construct sentences, you know how to make paragraphs and subparagraphs. But that's of no use to attorneys and advocates. What you want to learn is firstly that writing involves a process of thinking. You need to learn to think like a lawyer. Lawyers think differently. Lawyers are not people who resort to instinct. We are people who apply logic, rationality. That's what makes a good lawyer. Now, when you translate those qualities into your writing, you write well. So it's not really about how to write, it's about what to write. Now, there's a disease that has inflicted lawyers in this country, and it has for centuries. That disease is called a precedent. Now, I've been criticized by colleagues that in this course I do not provide a precedent. Now, first of all, a precedent is of no use in drafting heads of argument. Each time you draft heads, it's different, and there is no precedent for it. And I will show you during this course that you are no longer allowed even to copy and paste from authorities, because again, it's useless. As far as heads are concerned, what is a judge looking for? A judge is looking for your thought processes. You make a submission, how did you get there? What is the evidence that supports it? How did you apply the law? Does it make sense? Is it logical? That's what a judge is looking for. If you give a judge pages of copy and paste from authorities and textbooks and so on, it's of no assistance. In fact, it got so bad that in the SCA, in the Constitutional Court, that practice has become banned. You cannot copy and paste anymore. So let's talk a little bit about analytical thinking. Now, the first thing I want to talk to you about is sorry, I'm having all right. This might sound a bit obvious, but it's worth repeating. What do you need to be a good lawyer? When I'm talking about lawyer now, I'm talking about people who are involved in dispute resolution. I'm not talking about chamber lawyers, conveyancers, people who draft commercial documents. I'm talking about a lawyer involved in dispute resolution. That would be litigation, arbitration, mediation, and so forth. It forms a big part of our work, and you need the skills. Now, the first skill, I say, for a lawyer is excellent literacy skills. If you don't have literacy skills, you are not going to be able to comprehend easily. You will not write lucidly. And I will, at the end of this program, talk to you about how you could possibly improve those skills. Most of you would know that one of the problems facing South African LLBs is that they come out of university with poor literacy skills. We're not going to talk about why that's the case. We're going to talk about how you improve that. As a lawyer involved in dispute resolution, you have to be very organized. Now, the most important thing to organize is not your desk. It's not your office. You must learn how to organize the facts of your case. You must be a person who will persevere. There's one thing you must understand about dispute resolution. Nothing works the way you planned it. Something always goes wrong. You probably heard lawyers say there's no such thing as a case that you can't. Something can go wrong, and it usually does. What you want is to be a person who sticks the course. You don't give up. You continue to persuade a judge to accept your client's version. Time frames. We know as lawyers, especially in litigation, everything comes with a time frame. If you look at the uniform rules, there's a time frame. If you look at the time for filing heads in the SCA, there's a time frame. Filing written argument in the Constitutional Court comes with a time frame. Everything comes with a time frame. You have to learn how to comply with those things. Lawyers are notorious for time frames. I mean, go to the motion court. You will see one application after another dealing with condonation. Somebody's out of time. That just doesn't work. It's a waste of costs, and quite frankly, irritating to the other side and to the judge. Then there's 2 points that I want to deal with finally. The first is you must be a lawyer who is able to see the point. Now, we confront problems that our clients bring us, and they come to us to resolve those problems. Clients come to us with a dispute. They want us to assist them to resolve the dispute. When you go to court, you present the judge with issues. Your job is to assist the judge to resolve those issues. You can't do those things if you are unable to see the point. Now, what do I mean by this? You must be the sort of lawyer who looks at a set of facts and says, hold on, I've got the answer. Or isn't this the issue? Now, this is something that you won't learn overnight. It comes with experience. But it only comes with experience if you practice the correct method of analyzing fact, being able to apply logic. It's only then that you'll train yourself to see the point. We've all been in court. How often do you hear a judge say, Mr. Smith, I don't see the point? Or what is your point? Or is there a point in this paragraph? Now, that's what a good lawyer does. You can see the point, and most importantly, you can make the point in your heads of argument. The last point is work out probabilities. Now, this is something lawyers overlook, and it is the most fundamental part of being a good lawyer. What does this mean? When your client gives you a version, in other words, a set of facts, what do you do with it? You're not supposed to just write it down and accept it on the basis, well, those are my instructions. That's a bad lawyer. What does a lawyer do? A lawyer looks at this version and asks himself a simple question. Is this version likely to have happened? In other words, is it probable? Will a judge accept it as probable? Now, all I'm saying is, if you go to court with a version that a judge is not going to accept, you are wasting your time. You are going to lose. Now, remember, we use the adversarial system of dispute resolution in our courts, and we also use it in arbitration. What that means is the judge does not investigate the evidence. The judge just sits there as a neutral trier of fact, and the parties have to tell the judge or present the evidence which will contain the facts of each side's version. Now, what does a judge do? Now, it's not easy for a judge doesn't know if a witness told the truth. When a judge says, I find Mr. Mokoena to be a good witness, all the judges say, for the purposes of this hearing, I am persuaded that he told the truth. It doesn't necessarily mean it is the truth. Now, if judges don't know if a witness is telling the truth, or if a judge reads an affidavit and doesn't know if the deponent is telling the truth, so what does a judge do then? They still have to resolve a dispute of fact. Well, this is what judges do. They look at the facts and they test the probabilities. They look at each party's version and ask the simple question, bearing in mind the undisputed facts of this case, how likely is this version to have happened? You all know that in the civil courts, the onus is discharged on a balance of probabilities. I've just explained to you what that means. In simple language, if you go to court with a rubbish version, one that is not likely to have happened, you are going to lose. And just be warned, this old excuse that lawyers have when a judge says, hey, listen, do you really expect me to believe that nonsense? What does the lawyer say? Well, my lord, those were my instructions. And that seems to be a convenient way out. Well, that's not the case anymore. Because a judge is going to say, well, that's your instruction, but you're still an officer of the court. Why do you present me with this nonsense? Well, how do you get around to working out probabilities? By applying your mind, not merely by writing down a statement from your client, but applying your mind to it, listening, analyzing, asking. There are three simple questions. Is this version relevant to the issue? Will my client's evidence be admissible in court? And is this version probable? Now, if you are not able to do that, you can forget it. You are no longer thinking like a lawyer. You need the ability to break down facts, to look at strengths in your client's version and weaknesses. You need the capacity to think, to solve problems, analyze information, recall and use information. That's what a lawyer does. Now you're thinking like a lawyer. Give you an example. When client walks in and says, issue a summons, if you don't get all the facts, what you'll do, and this is what happens a lot, unfortunately, the attorney will go and look for a precedent, which he thinks is a convenient and a relevant precedent, sends out the summons. And then they discover much later, when it's too late and very embarrassing, that they've got the wrong cause of action, or that the pleadings do not accord with their client's own version. And this is what causes the postponements, that's what causes the delays and the costs. So the thinking is the most important part. And I told you, identifying the issues is an essential skill. If you're one of those lawyers that can put your finger on the issue very accurately, you'll be a successful lawyer. On the other hand, if you're one of those lawyers who just doesn't see it, you will usually make misdirections in court and you'll have a poor outcome. Now, many of you have sat in court. Go and listen to experienced judges. Go and see how they deal with matters. An experienced judge will walk in and tell counsel or attorneys, look, I've read the papers. Isn't this the point? And you'll see that both sets of lawyers will glance at each other, they'll look up and they'll say, yes, that is the point. And 20 minutes later, the matter's finished. Now, that is what a good lawyer does. You must be able to recognize issues. You must be able to look at the facts. And please remember, before you look at the law, go and look at the facts. You get the facts wrong, the law is of no use to you. You're still going to lose the case. If you can, put your finger on the main issue. It prevents loss of time. And as you know, there's nothing more irritating to a judge than to have to deal with issues that are not really necessary for purposes of resolving the dispute. Organizing the information is vital. Merely taking instructions in the form of statements from your client and from witnesses, receiving documentation, and gathering the documents into files, that's not organizing the information. When you get the facts, there's a method that you should use in organizing the information from your client. Now, let's take a simple technique. When someone gives you a set of facts, I told you, don't merely write it down. A very good technique is to listen to the person talking to you first. Could you mute your, somebody has not muted their system, so it's causing a, okay, that's better. As I was saying, one of the best things you can do as a lawyer is to listen to your client, is to listen to your witnesses. And that is listening actively, not listening for the purpose of writing it down. Listening actively is when you listen like a lawyer. Listening like a lawyer means, firstly, do I understand the version? What is meant by version? It is what happened according to your client's version. What does your client say actually happened? Then the lawyer is thinking, is that likely to have happened? Let me test it against the undisputed facts. Do the undisputed facts support this? Or does it make nonsense out of it? Will a judge buy it? Now you're thinking like a lawyer, and you organize your facts accordingly. You are now beginning to analyze. Analytical skills includes the ability to apply thinking to gathering and analyzing information. I gave you a good example of how you do that. Merely reading cases, textbooks, merely gathering the facts amounts to nothing useful. You have to apply your mind as you read. Now, I will come back to this. It's the technique of writing as you read. The reason I encourage lawyers to write as they read, in other words, if you read something, let's say you read a judgment and you think this is relevant to your case, your client's case, don't mark it or write down the reference. Open up a file on your computer and write down in your own words what you understand from that judgment and why is it persuasive for your case. Now, when you start writing this down, it immediately tests your understanding, because when you start writing and you get stuck, you're not sure why this is relevant or you can't express it. It simply means you never understood it. You thought you understood it. When you write, you force yourself to think. button. That's the most important bit. Now, I'm going to show you a method. I dealt with this already. What you should do is write down, open a file and write down the material facts of your client's case, the main facts. But you're a good lawyer. That means you will write the facts down in a chronological sequence. Now, here's the thing. Part of logical thinking is that you constantly arrange your facts in a chronological sequence. When your sequencing is wrong, that's when a judge will say, but hold on, this can't be probable. Your version is improbable because it doesn't make sense sequentially. And I've seen this in hundreds of cases where the lawyers got the sequencing wrong and went and lost the case. Not because their clients had a bad case, it's because they didn't handle the facts correctly. Now, once you've set out the main facts in a file, you would have written them down. By writing them down, you are applying your mind as to whether this is material, and if so, why is it material? It improves your understanding of the facts of your case. You will ask these questions. Is it supported by the undisputed facts? Will they support a cause of action? Now, what is meant by cause of action? Cause of action simply means the facts which the law recognizes as giving you a claim. So those of you who want to issue a summons, write particulars of claim, or, as I will show you, write heads of argument, you will write down the material facts. And then you will look at those facts and say, do those facts support my client's cause of action? If they don't, then you have no cause of action. Or you may have pleaded an incorrect cause of action. You also need to look at your material facts and ask the obvious question. If I can prove these facts, what am I entitled to? What remedy am I entitled to if I can prove this in court? Now, very often lawyers take instructions and they don't apply their minds to the remedy. Always ask the client, what do you want? What do you expect from this trial, or from this hearing? And then remember, our system is adversarial. You will have an opponent, you'll have there'll be a defendant or a plaintiff. How will they deal with your facts? A good lawyer will ask that question. So I'm going to, what I'll do is I'm going to play a little game. I usually play this game with in a live session, but I'm going to try and see if I could test you. Take a look at this, what's on the screen now, and tell me if you think it's logically valid. All roses are flowers. Some flowers fade quickly, therefore some roses fade quickly. Is that logically valid? Now, some of you might think, yes, it is. And others will say, no, it's not. The correct answer is, no, it's not. Well, why is it not logically valid? Because prima facie, it looks perfectly valid. But a good lawyer will notice that all roses are flowers, but we don't know if flowers are included in some flowers that fade quickly. Therefore, you cannot say that roses fade quickly. You see, I mean, this is just an exercise in logic. Those of you who are interested in logical thinking, let my coordinator know. I will send you some material that you can read that will improve the way you apply logic. Now, here's one. Now I'm going to play another game. There's going to be a question. I want you to answer it immediately in your mind. You know, like you're in primary school. Teacher asks a question and everyone goes, me, I want to answer it. Just give me the answer. Here it is. How many animals of each kind did Moses take into the ark? Well, I can assure you, there are many of you who said 2. The correct answer is none, because it was not Moses who took the animals onto the ark. It was Noah. Now, if you said 2, don't feel bad about it. You're not stupid. What happened to you is that you were not applying your mind, you were applying instinct, intuition. And here's how it works. We all know that Moses and Noah are biblical characters. So your focus was on how many animals. You didn't look at Moses. But who you were thinking about is Noah. But if you looked carefully, you would have realized that Moses didn't take any animals into the ark. It was someone else. So what I'm saying is lawyers do not apply instinct. They apply reason. And I'm going to stop with this now. Usually in a live program, I would play lots of games with you around logical reasoning, but logic is at the very heart of drafting heads of argument. One of the things you will come across when you, sorry, I'm just going to be changing my programs while I talk to you. If you right, oh, here we go. If you are going to write heads of argument, what the judges are looking for is your reasoning. They're not looking for your authorities. They're not looking for what the cases say. They want to see you applying your mind. When you say, I rely on X versus B, SCA decision, the judge doesn't want to know what the judgment says. The judge wants to see you apply your mind. The judge wants to see the reasoning. Why is it that this judgment supports your argument or your submission? Copying and pasting from the judgment is of no use to anyone. So, what happens with heads of argument? It's an opportunity where you can pull the whole case together. You combine your argument and evidence in a manner that is so irresistible that the judge will wonder how the other side can possibly have a case at all. Until, of course, he reads their side of the story. What I'm saying is, heads of argument must be persuasive. And I will show you what is it that makes heads of argument persuasive. And the whole purpose of this course is to get you to draft so that it is persuasive. A judge must read it, understand it easily, see your point the first time, and must like it. Now, before we get to the writing heads itself, there are 4 concepts that I want to take you through. Now, I'm warning you, these 4 things are absolutely essential to you. Please make a careful note of it and learn how to use it. The first one is you must know your case concept. Now, what is meant by case concept? Case concept is knowing what happened according to your client's version. What actually happened according to your client's version. Now remember, if you're involved in a dispute, you are going to you are going to be confronted with your opponent's version as well. Your opponent will come to the judge and say, here's my case concept. This is what happened, what actually happened according to my client's version. And this is key to the whole thing. Now, I found an excellent definition of cause of action, or rather concept, case concept. It's also called the theory of the case. And I want you to take careful note of this definition. It is a definition by Thomas Mawer, who is a silk practicing in Australia and in England. And he wrote a book on litigation skills. And this is what he said. Theory of the case or case concept is a logical. You see, the first word he uses is logical, persuasive story of what really happened. Now, for any story to be persuasive, it must be logical. For it to be logical, it must be something that is likely to have happened. If you have a story that is not likely to have happened, then it lacks logic and it will certainly not be persuasive. It is your position and approach to all the undisputed and disputed evidence that you anticipate will be presented at trial. Now, when you go to trial, or if you are going on appeal, you have to consider your client's version according to, firstly, the undisputed facts. Now, this is an area that many lawyers get wrong. First of all, they concentrate heavily on the disputed facts, which is not a bad thing, but they completely forget about the undisputed facts. In every dispute that you get involved in, be it in an opposed motion, a trial, an appeal, there will always be a set of undisputed facts between the parties. A good lawyer will ask the obvious question. Well, it's not so obvious. Will the undisputed facts support my client's version of the dispute? If the answer is no, there's something wrong with your client's version of the dispute. It's probably improbable. Now, let's get one thing straight. When a judge says your version is improbable, that's a polite way of saying you're a liar. Okay, that's all it amounts to. And as a good lawyer, you should never be afraid to say to your client, I don't think that version is going to be accepted by a judge. And let me tell you why. It is improbable. It is not supported by the undisputed facts. Your opponent will be able to answer it easily. Okay. Now, developing a theory of the case is the process of integrating the undisputed facts. You see the importance of the undisputed facts with your version of the disputed facts to create a cohesive, logical position which eliminates the evidence in the most favorable light to your client. It's cohesive, it must be cohesive, it must be logical. When a judge hears your client's version, the judge must go, of course, that's what happened. I like that version. It is likely to have happened. It's supported by the undisputed evidence. This position must remain consistent through each phase of the trial. When at the end of the trial, the judge is faced with the question, what really happened? Your position must constitute the most plausible explanation. Now remember, the judge was not there. You were not there. What's going to happen is that the judge is not going to ask, is that version true? Because that's not going to help. the judge is going to ask, is that version likely to have happened, given the surrounding circumstances of this case? If the answer to that is no, well, you've lost the case. Simple as that. So it's your client's version of the disputed facts. This is your explanation of how the events are likely to have happened. As a lawyer, you need to know what really happened. You cannot draft heads of argument without knowing this. You cannot start an action or a motion without knowing this. It is the central theme of your case. All right. The next point that you must practice and understand is what is context before detail. What is meant by context before detail? Another way of putting it is point first writing. What does this mean? It means that when you make a submission to a judge, in your heads, on your feet, in an affidavit, you first tell the judge what the point is before developing the details of it. In other words, tell the judge what your point is, and then say, here is how I developed it. You'll refer to the evidence, you'll refer to the law. If you do it the other way around, where you start explaining the details and then conclude with the point, there's a problem there. By the time you conclude with that point, the judge doesn't agree with it. Whereas if you told the judge up front what the point is, you've poisoned the judge's mind already, and you got the judge thinking the way you want the judge to think. And I will show you many examples of this during this course. So how do we deal with this? I think the best way is to illustrate it is with an example. Let's say you want to make a submission that the defendant was negligent in that he, as a doctor, administered the wrong drug. Okay. Don't start writing this by giving the details. On such and such a date, the plaintiff was treated by the defendant. On such and such a date, the plaintiff was admitted to hospital. At the hospital, the defendant diagnosed the plaintiff as. Next paragraph. On such and such a date, the defendant administered cortisone to the plaintiff. Next, plaintiff had a bad reaction, became seriously ill. You see, you're giving the details. But what's your point really? The point is the defendant was negligent. So the best way to draft that, firstly, you'll have a heading. The heading says plaintiff's negligence. Next line, first sentence. Sorry, defendant's negligence. First line, defendant was negligent in that he administered the incorrect medication to the plaintiff who was gravely ill. Now the judge sees the point. You've made your point. Now you tell the judge what happened. You see, it's called context before detail or point first writing. It's fundamental technique for writing good heads. Now, one of the things I will show you is that courts, judges, prefer short heads. Lengthy heads are useless, okay? And you will see that we have page limitations now imposed in most of our courts. They started in the SCA, the Constitutional Court does it, and now the High Court, I know certainly in Gauteng, there are page limitations on heads. When you use point first writing, It's one of the techniques that will help you to write short heads. The third technique, and this is one of the most important techniques, and that is write as you research. Write as you think. Now, what does it means that when you research, let's say you have to draft heads, and you're researching a point of law. Let's say it's on disputes, it's on breach of contract, or it's unjust enrichment, or it's reckless conduct of a director. Whatever the problem is, you are going to research. Now, while you're researching, now you're going to do two things. You might start with a basic textbook, but your main research will happen by reading the judgments, law reports. That's where the authority is. Remember, we're a common law country, which means that the law is in our law reports, not in textbooks or articles. So you read a judgment. You will be a bad lawyer if you see a passage in the judgment and you say, that's it, that's what I'm looking for. So you scroll across it, you copy, and you paste it on a document. And you write down the reference. And you park it somewhere. Well, you've achieved nothing. Okay. What you're supposed to do is not to copy and paste. You're supposed to, instead of copying it and pasting it, you should read it, understand the point, and be able to write it in your own words. But you write it immediately, not flag it and keep it somewhere and then you'll read it afterwards, because that's double the work. Okay. I'll show you as we go along that this method will do two things. It forces you to think, and secondly, it makes you more efficient. You become better at drafting heads. And the fourth one, you have to be clear. In other words, if a judge reads through a page and can't see the point, then that's a bad set of heads. You have to keep it short. There's an old joke where saying to the judge, "My lord, I didn't have time to write short." I'm having a sign on my screen that says network is causing poor call quality. Switch to a better network or closer to Wi-Fi access point. Listen, can we just pause for a moment? I'm going to call my coordinator. Okay. Stephanie, just come through here. Oh, it's gone. I had something on my screen that
Okay. You can now go
See
again.
that one?
Yes. Now you can talk to them now.
All right. I must apologize. I was not aware that you are not seeing the slides changing on your screen. It's a pity because those games I was playing earlier required you to see the slides. But anyway, I'm going to go back a little on, I mentioned 4 important points. The first point is you must know your case concept. What happened according to your client's version of the disputed facts? When do you do this? Right at the beginning. Before you issue a summons, before you issue a motion, and if you are writing heads, the process had already started. If you are running a trial, your heads start taking shape when you issue the summons, when you start consulting with client. If you are in an appeal, your case concept takes shape starting with the grounds of appeal, and I'll deal with that later. So you must know your case concept. Number 2, what is meant by context before detail? Make the point first. I will show you later that when you write good heads, you start by saying, this is the background. Here are the issues for you to decide, you're saying to the judge. But the first thing you do after defining the issue is to say how you want the judge to resolve the disputes. In other words, here's the problem. Let me give you the answer, and then I'll tell you how I got to the answer. That is called point first writing. The third technique, write as you research. Please stop this nonsense of reading and parking it, hoping you'll either remember it or you'll go back to it. It is of no use. The main benefit of writing as you research is that you are forced to apply your mind. You'll really start understanding your case when you do this. And then the fourth is to keep it clear, keep it short. No one wants lengthy heads of argument. You must be relevant and keep it logical. Okay, then, let's move on to a few other items. I want to talk a little about persuasion. Good lawyers are good communicators. Now, what happens when you write heads? You are communicating with the judge. You are telling the judge what your case is. You're telling the judge why you should win. And your heads of argument must be persuasive. And I'll show you how you do that. When you write heads, it's what I call written advocacy. There's the oral advocacy that takes place in court, but much of it depends on the written advocacy. Now, let me pause there for a moment. If you are involved in dispute resolution as a lawyer, you must learn how to write heads. More and more, our courts are requesting heads of argument. I will show you that there are certain procedures where it is compulsory to file heads. But we now have a situation where, because of inexperienced judicial officers, they require the assistance of heads of argument. So if you write good heads, you have a better prospect of persuading the judge than if you wrote no heads and merely relied on your oral advocacy in court. Now, here's a problem with oral advocacy. If a judge or a magistrate reserves judgment, within a matter of hours, they've forgotten your persuasive argument. They can remember that they were quite impressed with you, but now they can't remember why. That's where the heads of argument come in. The written heads act as a reference point, and they can be absolutely crucial to your case. Now, what makes persuasive heads? Now, there are some ingredients that have to go into it. Firstly, it's the facts. Now, most cases in court, first involve the resolution of any disputes of fact. You cannot apply the law until you've resolved the disputes of fact. In other words, the judge must first make a finding of fact before he can apply the law. That's the logical sequence. You are expected to apply logic, and then come the legal principles. Now, what is meant by legal principles? It's what the authorities are saying, but it is how you apply that authority to the peculiar facts of your case. That's what really matters, and that's where the thinking comes in. If you merely copy and paste from a judgment, it doesn't help the judge. Now, the substance of your writing, in your heads, and the manner in which you present it will determine just how persuasive it is. The two go hand in hand. The one is a question of style, the other is a question of substance. Now, what we've done in our courts, especially in the SCA, in the Constitutional Court, is that they regulate the style. You are told how to set out your heads. But the style of writing is unique to everyone. You have to develop your own style. Now, the first lesson is that you must write in plain language. Straightforward language which conveys its meaning clearly and simply, without unnecessary pretension or embellishment. A communication is in plain language if the language structure and design are so clear that the intended audience can easily find what they need, understand what they find, and use the information. In other words, you must write in a manner where what you write means only one thing, what you intended it to mean. You will achieve this by writing plain language. We want no more legalese, no more big words, no more bombastic language, no more complex sentence construction, okay? Now, when you write, what you need to understand is who you're writing for. Who's your audience? When you write heads, your audience is a judge. Maybe one judge, two judges, or even 9 judges. Plain language is directed at the convenience and ease of reference of the reader, for the reader. And here are the things you need to do. Firstly, the reader never needs to go back to the beginning of a sentence and reread it to understand it. Now, if a reader has to read your sentence again and again to work out what's going on, that's poor drafting. Your sentence is probably too long. Your sentence probably covers more than one subject, and it becomes confusing. That's poor writing. Now, here's a tip for you. I spent many years on the bench. When a judge reads a paragraph in heads of argument or in an affidavit and doesn't understand it, how many judges do you think go back and read it again and even read it the 3rd time? Well, I got news for you. They're too busy. They haven't got time to keep reading the same paragraph. What they do is that they just move on. They would have moved on and missed a very important point that you made, but you buried it in bad writing. So don't write complex sentences using big words and legalese. A reader never needs to stop and examine the sentence in order to understand its structure. They just read it effortlessly and understand it. They can always see how the next sentence follows on from the one before. There's a sequence. It's coordinated. They don't find words they do not understand. A lazy reader will come across a word they don't understand. They're not going to stop and look it up. They're just going to read on. And again, may have missed the point. And the trick is the reader must grasp what you are reading, what you have said in one reading. And the test is simple. The reader understands at the same speed as they read. And that's how you should write. That's how you write heads. Lawyers are notorious for using legalese or jargon. Jargon is when you use words and phrases only you can understand or some of your colleagues can understand. Legal professionals now are encouraged to follow the plain language movement. In other words, good legal writing means plain language writing. And get into the habit of writing plain language. We don't use foreign languages much now, but people of my generation, we had the habit of using lots of Latin in our writing. It looked important, it looked clever, but no one understood it. We don't do that anymore. Well, most of you would not have studied Latin. Many of my colleagues also studied French, and they would roll out some French phrases in their heads of argument. We just don't do that anymore. Plain English. Well, there's a legal writing institute it's based in London, and it targets not just lawyers, but all professionals. When you write for people, for members of the public, whether you're an accountant, engineer, scientist, doctor, lawyer, doesn't matter. All of us use plain language. And legalese is not necessary. It is not more precise. I mean, why do lawyers, when they cross-referencing a paragraph in their heads, you're writing paragraph 8, but you want to cross-reference paragraph 4? Instead of saying referred to in paragraph 4, no, it will be referred to in paragraph 4, herein above stated. I mean, what a lot of nonsense. Why can't you say paragraph 4 above? Or simply paragraph 4. Where else is that paragraph 4 going to be? So stick to plain language. Now, here's a practical tip. No lawyer was ever taught at university to use legalese, words like hereinafter, herein before, heretofore, ipso facto. Nobody taught us to write like that. But first year in practice, either as an article clerk or as a pupil, you start writing this legalese nonsense. Where does it come from? It comes from old precedents. When you enter a law firm, the first thing you get told is start collecting your precedents. You must have a precedent file. And then you write letters, a simple letter, but it'll be full of legalese. And most of it is nonsense. I mean, you all know about it. For instance, you write a letter on behalf of your landlord client to his tenant, cancelling his lease and putting him on terms to vacate. So you do that. Your lease is cancelled. Our instructions are. You notice that every letter starts with our instructions are. I mean, for God's sake, why? You're copying a precedent. But this letter goes on and he says, your lease is hereby cancelled. You are to vacate your premises by a certain date, failing which we will obtain an order and we will evict you. Your goods will be thrown out on the pavement. You will pay attorney-client costs. And then you end the letter with, we trust the above is in order. Have you seen that? You write letters to people threatening the most dire of consequences, and then you say, we trust the above is in order. I promise you, go and find 10 letters at random written by attorneys. You will see it ends with, we trust the above is in order. Where does it come from? No one taught you that at university. Comes from an old precedent. So stop using old precedents. Now I've dealt with this. One of the things about writing is you must know who you're writing for. Are you writing for your client's errant tenant? Or are you writing this for a judge? Are you writing this for a magistrate in Germiston? Or are you writing this for a judge in the Constitutional Court? You always consider who's going to read your document, okay? Because you want to write in such a way that you reach that person's mind immediately, seamlessly, and effortlessly. Never forget who's reading your document. I've dealt with context before detail, but I want to just take this one step further. I said that you must always tell the reader what your case is about. Always set out your most important points up front. Remember, lawyers have this thing called the bullet point. This is the silver bullet. Don't bury it somewhere. State it up front. Now, when you draft heads, a good technique is right at the beginning of your heads to tell the judge how you set out your heads. So you'll say something like this. In the paragraphs that follow, I deal with the matter as follows. In part A, I set out the undisputed facts. In part B, I make reference to the material dispute between the parties. In part C, I present the evidence which shows that my client or the applicant or the appellant has the most probable version. And in part D, I will set out the remedy that we seek. Something like that. So when a judge reads this up front, the judge knows exactly where these heads are going, and he's able to follow. But you must be smart. When you're giving a judge a heads up or a roadmap up front, you must already start poisoning the judge's mind. So where you'll say, in part C, I deal with the negligent conduct of the defendant. Okay, so you don't say I deal with the defendant's version. You are for the plaintiff. You'll say I will deal with the negligent conduct of the defendant. So already you got the judge thinking the defendant was negligent. Okay, so that's the way to do it. Now, this is the next thing. When you're writing heads, you must be able, number one, to identify the issues that the judge needs to resolve. And number two, you must be able to frame the issue. In other words, state it in a manner that the judge understands it. It must be brief, and the judge must know that I need to resolve A, B, and C. Now, very often, you may recognize three issues. Good lawyer is the one who can understand the three issues, but can pick on one issue which, if the judge resolves it, will be dispositive of the whole case. Now, judges love this, and please remember it, because it makes less work for the judge. So you're saying to the judge, there are three issues, my lord, but you needn't deal with number one and number three. you only need to deal with number 2. Now, judges like that because it's efficient, it's less work, the matter is dealt with quickly. And that, by the way, happens a lot. The opposite of that is when you give the judge a whole lot of issues, most of which are either not relevant to the dispute or does not assist the judge in any way. Irrelevance is the most dangerous thing you can put in your heads of argument. Simple. You want to switch the judge off, present the judge with facts and submissions that are irrelevant to the issues. Now, stating the facts. In all of your heads, you will have to state what the material facts are. If you're writing heads for a trial or for an opposed motion, you have to deal with the facts, the material facts of your case, and they must be in a chronological sequence. Now, I'll tell you why chronology is so important. Judges have realized through experience that if the chronology goes wrong, then the judge can easily make an error of fact because of an incorrect chronology. So what's happened recently, and this is quite a recent development. When I was a young counsel, we didn't do this. We were not asked to. These days, in the SCA, Constitutional Court, High Court here in Gauteng, you are expected to prepare a chronology table or a chronology document which sets out the material facts in a sequence where you state the material fact and you state the date. You state what the document is and you state the date. That is what judges require. It works brilliantly. It is compulsory now in the courts I've just mentioned for you to file a chronology table. What you want to do is not make your reader do the work. You have to do the work. Good heads are read easily, understood immediately, and they are persuasive. And let me tell you, the more easily your heads are understood, the more persuasive they become. If your heads make the judge do more work than necessary, the less persuasive you become. That's a fact. Use headings when you draft your heads. Use headings when you draft particulars of claim, when you draft an affidavit. Why do you use headings? Remember, context before detail. Point first. When you use a heading, it immediately tells the judge what's coming. For example, you're drafting an affidavit in an interdict. So you put in a heading, clear right. Now we know that is a requirement for an interdict, one of the requirements. The judge will be looking for it. And you've got the heading, clear right. The judge knows what to look for. It is easy to reference, and it tells the judge what to expect in that paragraph. Point first. So get into the habit of using paragraphing and headings, and if necessary, subheadings. Now this one, write short paragraphs. I'm going to emphasize that whatever you write, you have to keep it short these days. Lengthy writing, long founding affidavits, long answering affidavits, long particulars of claim, long heads, not persuasive. Judges hate it, okay? So why do you want the judge to hate your writing? That's bad technique. Give the judge what they want. Short, sharp, to the point. Plain language. Short paragraphs are very user-friendly. For every fact set, use a separate paragraph. What this does is, these paragraphs are numbered differently. When the reader reads the paragraph, the reader sees the point. It may be a fact, it may be a submission or a combination of those two, and then moves on to the next paragraph. Moving on gives the reader an opportunity to digest what they just read and then move on to the next paragraph. The problem with long paragraphs is that you'll read page 1, page 2, page 3. Now you come to the end of the paragraph. Now, how many people understand or can remember everything they read in the past 3 pages? Well, it's difficult. And if you're writing long paragraphs, invariably you are writing using long sentences, and you may be making too many points of fact, too many points on the law. And the trouble with too many points is that the reader will not remember all of them. They'll remember 1 or 2, and then you've lost the others. So write short paragraphs. And then we have form and format. Now, it's a human condition. Nobody likes to read a busy document. A document where you used a small font, no spacing, and it's crammed all onto one page. You may have written brilliantly, but no one will want to read it. It just doesn't encourage human beings to read. That is why we make it illegal now to write commercial contracts, consumer contracts in small print with no spacing, difficult to read. Well, judges are human. They like to, they have an enormous reading load. And if your document is not user-friendly, well, they're going to struggle to read it. And that's not your object. You want to make it easy for the judge to read. Now, how do we do that? Our courts have provided for this in the rules and in the practice directives. I will come to this when we get to the various courts. So, as far as form and format is concerned, all you have to do is read the rule of that particular court and read the practice directives for that division and comply with it. I told you that lengthy heads are not persuasive. You know, lawyers have this habit of equating length with effort. I think it comes from the old tradition when, as attorneys, or attorneys will know that there's this thing called charging per folio. So the more folios you make, the more you can charge. Well, I'm sorry, that doesn't apply in the courts. The more pages does not mean more quality. Usually, more pages means less quality. So, avoid repetition. Avoid inclusion of factual details and documents not necessary to resolve the dispute. In other words, if you want to keep it short, keep it strictly relevant. Don't stray beyond that rule. Too much detail could damage your client's case. It's like a lawyer in a trial who does a great job in cross-examining in the first hour, but he's still cross-examining after lunch. And by the time he gets to 4 o'clock, 2 things happen. The judge has stopped listening, and the judge has forgotten the good work he did earlier that day. Keep it short. Now, I can tell you that the longer the document does not mean that the writer worked harder. In fact, the opposite is true. It takes longer to write crisp, precise heads than loose, long, baggy ones. And so, in order to impose or to get lawyers to write short heads, most of our courts now impose a page limitation. And I'll come to that when we get to those courts. Footnotes, we all use footnotes. I'm saying only use them for references. When you have a footnote, use it for referencing. Do not make a point in it. If you have a good point, do not mess it up by putting it in the footnote, because no one's going to read it. Put it in your main heads. But let's assume you think it's not good enough to be in your main heads. Well, then why do you need it anyway? Get rid of it completely, because no one's going to read it in the footnote anyway. So footnotes are disruptive, and many people don't like it. Judges don't like it. Some do, but it is disruptive of your reading and understanding. I told you, write short sentences. You will do it by reducing the use of the comma in favor of the full stop. Long sentences require careful construction and are aimed at sophisticated readers. They require a great deal of effort, and you want your heads to be effortless. Another way you could write short sentences and be relevant, I told you be relevant, and use the active voice. So write sentences where you use few words and is plain to understand in only one way. Now the normal active construction of subject followed by verb object is usually the best. Now there's a problem in South Africa. We have a habit of writing in the passive voice. So we'll say the purchase price was paid by the plaintiff. What's wrong with saying paid the purchase price? You see how much more efficient that is. Messi kicked the ball. Isn't that, it's short to the point. But we here will say the ball was kicked by Messi. So avoid the passive voice. Now I'll tell you, if you're writing passive voice, don't be distressed about it, because it's a cultural thing. In South Africa, we're a nation of multilinguists, and very often you're thinking in one language and you're writing in another, and that's where the passive voice, the passive writing comes in. Good example is Afrikaans. If you're thinking in Afrikaans, where the verb is at the end, then you will write in the passive voice in English. There'll just be a quotations. There was a time when heads of argument didn't look like heads of argument. It was heads of quotations. Lawyers quoted copiously, firstly from authorities, and secondly, if it's an appeal or a trial, from the record. It is not persuasive. Judges hate it and they don't read it. What judges want is for you to make the point briefly in your own words and then give them a reference. You don't need to copy half a page out of an SCA judgment, paste it into your heads and give the reference. That doesn't help the judge. What helps the judge is to tell the judge what the point is and why it's relevant to your argument. You must be able to demonstrate the thinking. Now, I just point out here that in the SCA, if you read Rule 10, it tells you you are to limit quotations. And there are some reported decisions where counsel drafted heads replete with quotations, loads of it. They were punished with a cost order. They were disallowed their costs because of the overuse of quotations. The same applies in the Constitutional Court. However, when you're drafting heads for the High Court, even the Magistrates Court, refrain from lengthy quotations. They don't work. I've dealt with legalese. Stop it. Just get rid of it. Okay. These wheresoevers and hereinunders and hereafter. Only lawyers do that. Now, in your packs, you'll see what is called some general drafting principles. I'm going to, it's basically a summary of all the things I've said. It's a checklist for you. You should consult it yourself and apply it. Now, let's look at some rules, house rules, before you start drafting heads of argument. You must be familiar with, firstly, with the rules, the uniform rules. What do they require? Practice directives for each of the courts. The practice directives are peculiar to that court only. They don't apply uniformly. But the rules do apply uniformly. There are two types of rules. There are the provincial rules, or SCA rules, that apply to that court. There are constitutional court rules. And then there are what we call the uniform rules that apply throughout the High Court system. You must keep up with the amendments and the updates that appear from time to time. Unfortunately, our rules board is not very good, and the judges have now taken over, and they are directing how matters are dealt with through their practice directives. And this applies at every level of the High Court. So make sure you are familiar with that. Now, this is what you'll typically find with rules and directives. First of all, they tell you when you are required to file heads. Now, the SCA, Constitutional Court, they have a set of rules, and you know there that heads of argument or written argument in the Constitutional Court are compulsory. It's a requirement. It has to be filed. And those of you who will draft heads for the SCA and Constitutional Court, just remember there are various requirements. Things like a practice note. You have to file a practice note. You have to file a chronology document. You have to prepare what is called a core bundle. You have to indicate which parts of the court record the judges have to read and which parts are not necessary to read. Now, where will you find all of this stuff? It's in the rules and directives. Make sure you comply. The trouble is, if you don't comply, you end up, your matter could get struck off the roll. There could be cost implications, and there are enormous delays. Your client will be very unhappy. The format of heads, font size, paragraph numbering. Now, there's also in our courts a requirement for concise heads and comprehensive heads. If you look at the motion court in Johannesburg and Pretoria, when your matter is set down on the opposed motion roll, you have to file a practice note with concise heads and a chronology document. Okay. At the hearing of the matter, the opposed application itself, you can then hand up comprehensive heads. Now, what's in the concise heads? It's this: the issue, the main points you rely on, and the main cases. Now, let me say this about case law. There was a time, and I'm a big culprit, when you referred to case law, we had this habit of referring to as many cases as we could find on the point. So we would make a point and say, see the following decisions, and we'd give a list of 15 cases. Well, you don't do that anymore. And please remember this. All you need for heads now, I don't care which court, applies to all the courts. All you need is the most recent judgment of the highest court. That's it. If you've got that judgment, you don't have to refer to the rest. Now, there are some rules about this in the SCA and the Constitutional Court. If you refer to 3 or 4 judgments in respect of a single point, you have to explain why you decided to refer to so many cases. What's the reason? What's the justification for it? Okay, so you could be embarrassed. All you need is the most recent decision of the highest court. And that's all you refer to in your heads. And remember, your heads in the SCA, as well as in the Constitutional Court and in Gauteng, you will have to also provide the list of cases that you will rely on. Okay. So you will also see page limitations. You get 40 pages in the SCA. I think it's 40 pages in Gauteng. You get 50 pages in the Constitutional Court. If you want more pages, then you'll need the permission of the president of the SCA or the Chief Justice in the Constitutional Court. Now, let me just get one thing straight. If you couldn't make your point in 40 pages, you are not going to make it in 200, okay? That is why short heads are not easy to draft. They are difficult, okay? And then there's this, if you look at the SCA and Constitutional Court, there are a whole lot of directives around how they want your heads to be bound. They will deal with the binding. So let's move on to the next topic. Why do you need heads? Well, firstly, as a matter of procedure. In appeals, motions, Constitutional Court, any of our courts that enjoy appeal jurisdiction, it's a matter of procedure. They are compulsory, you have to file heads. Now, if they are not dealt with in the rules or in the uniform rules, please look in the directives. For instance, you will not see in the uniform rules that some of our provincial divisions require the filing of heads in opposed motions. You will find it in the practice directives. The format, how they want it filed, when they want it filed, etc., is in the directives. Your job is to comply. Now, why do we need heads? First of all, there is no better way of preparing, be it a trial, an appeal, opposed motion, than drafting heads. When you write heads, you are seriously preparing yourself, because now you're applying your mind, you're applying your mind to the evidence, you're applying your mind to the law, you can see the strengths of your case, you can see the weaknesses. There is no better way to prepare yourself for argument than to have heads. It focuses your mind and it takes you away from the habit of consulting precedents. You are going to use your own mind. They are helpful during argument in court. Now, most of you have been to court. You will notice that there are some judges who write notes copiously, or magistrates. They write everything. They'll even say to you, they'll say, Mr. Kumalo, listen, could you please slow down? I need to write this. Now, here's the problem. Remember, the judge is a human being. This is not a robot. When judges are writing, do you think they're actually listening? Your brilliant advocacy is being lost because the judge is anxious to write down what you're saying. The best way to present an argument, or one of your principal objectives, is to get the judge to listen. When a judge is sitting there making eye contact with you and listening to you, you have your best chance at persuading the judge. Heads do that. When a judge is sitting there with heads of argument on the desk, the judge knows the points are all there. The judge knows that the authorities are all there. The judge doesn't have to write everything down. So what is the judge going to do? The judge is going to listen to you. That is crucial. And of course, if a judge is going to consider judgment at a later stage, where they reserve judgment, they are going to use your heads as the reference points, and they really assist the judge. So heads are the extremely useful things to write. So what are the different types? In our highest court, we have written argument. We don't have heads of argument. We have concise heads in our motion court, or what we call short heads. Then we have comprehensive heads, which we call long heads. We have main heads of argument in the SCA, where you're on appeal. And you have heads of argument on trial. They're all different in their own ways, and we'll deal with those differences. In the Constitutional Court, you have to file written argument, not heads. Written argument, and here are the requirements, must not exceed 50 pages, double-spaced, 14-point font, and it must be written on one side of the page. You'll see a similar requirement in the SCA, but there it's 40 pages. You can exceed 50 pages, but it's in exceptional circumstances and with the leave of the Chief Justice. Only the Constitutional Court requires a table of contents, but I've also seen, and I've done it myself recently, where I've provided a table of contents for heads in the SCA as well. It must contain a table of authorities with reference to the pages in the document on which they are cited. So you'll have a set of authorities. It should be mostly cases. If it is not mostly cases, then you got your research all wrong. You forgot you were not at university. When you are in court, your best authorities are the cases. It's case law. It's a common law country. You will cite a case, and you will also make a reference to the pages in your heads where you reference them. Okay. Usually in a live session, I'll show you some examples, but you don't really need them. You can draft them on your own. This is something many practitioners forget. Practice notes, concise heads, and chronology documents. Practice notes and chronology documents are a requirement in the SCA and Constitutional Court as well. Make sure you consult the directives. But here's a tip, a practical tip. And I'm not advertising for anyone, but there are some firms in Bloemfontein which provide appeal services. I'm not going to name them. I know there's one that I use a lot. They are brilliant. They do everything. They'll tell you that you need a chronology document, in what format it must be. They'll tell you that you need a practice note. They'll tell you what needs to go into the practice note. They tell you how to prepare. In fact, they will prepare the court record. They will consult you on how to prepare the core bundle. They will tell you how you indicate which documents must be read and which part the court doesn't have to read, and so on. So it takes all that weight off your shoulders. You pay these people. They are worth it. They do all that work. So you can concentrate on writing the heads. Let them take care of the admin. Okay, Supreme Court of Appeal. You have to go and read Rule 10. Now, please don't even start writing for the Supreme Court of Appeal until you've read Rule 10. And there are also some directives. Make sure you read that. The page limit is 40 pages. The format, what font, double spacing, what kind of paper, what kind of binding, the whole lot is in Rule 10.3. Go and read it. So I've taken you, here's some of the rules. 10.3a, one says heads of arguments shall be clear, succinct, and without unnecessary elaboration. Okay, now follow that, apply that, and you will come well within 40 pages. Many practitioners struggle to get their heads within 40 pages. That's because their writing technique is poor. Each point should be numbered and be stated as concisely as the nature of the case allows, and must be followed by a reference to the record or authority in support of the point. So they tell you how to draft. They're telling you this is how we want it drafted. Now, when they say each point should be numbered and stated concisely, that would be in a paragraph. Each point is in a separate paragraph. That paragraph, we're going to practice point first writing. So the paragraph's got a number. It will have a heading. That heading will say what the point is. Okay. Breach of contract. Okay. That's the point. Liability for unjust enrichment. So you've got a heading, and then your very first sentence must contain your main point right up front. That's the way to draft heads. They tell you that you are not supposed to copy and paste from authorities. Heads of argument shall not contain lengthy quotations from the record. It must state, in respect of each authority cited, the proposition of law that the authority states. And if more than one authority is cited, the reason for citing the additional authority must be stated. So that's another way of saying all you need is one case. That's the most recent decision of the highest court. If you want more than that, please tell us why. Okay. Now, they want you to state the proposition. How do you do that? Read the judgment. What is the point that you want to use? What do you see as the ratio, and why is it applicable to your set of facts? Or why is it relevant to the dispute? Simple. When you've read the judgment, don't copy and paste. Write it. Start writing in your own words what you see is the proposition of law. Explain it in your own words. Now, if you can't do that, if you're struggling to explain it, it means only one thing. You didn't understand it. You thought you understood it. Now, here's the beauty of writing heads. When you do this exercise, when you're writing in your own words what the judgment says, you are applying your mind. You begin to understand. And as I told you, write and save. Write as you read. Never read and keep one side with the intention of coming back to it when you write. You will just double your work. That's all. It's not efficient. References to authorities and the record shall not be general. You must have specific pages and paragraphs. These days, it's quite convenient to refer to paragraphs because judgments, as you know, the modern method of writing judgments is to use numbered paragraphs. And I think these days, all of our courts, you write judgments using numbered paragraphs. The trend was actually started by the Constitutional Court. The heads of argument must have a chronology table duly cross-referenced. If a respondent disputes the correctness of a table, in other words, it happens where the two parties, appellant and respondent, can't agree on the chronology, there's a dispute, then you file separate chronologies. Otherwise, you are expected to consult one another and file a single chronology. Now, in most of the cases that I've dealt with, the parties usually come up with a single document that sets out all a chronology of all the material facts. There's very rarely a dispute regarding chronology. If there is, then it is usually one of the issues. It may be an issue of fact that will have to be dealt with. Okay, we've got 40 pages and they tell you that it must be typed on, I like this description, stout A4 standard paper, double spacing, black record ink on one side only. Now I can warn you, if you don't comply with this, it doesn't get past the registrar's office, they will send it back. And God help you if you are then out of time when you have to correct it and bring it back. Then you have to bring an application for condonation. And there's no guarantee you will get it. Now, let's go to motion court. I will obviously come back to these various courts when I deal with the substance of your heads of argument. In Gauteng, and some of the other provinces, those of you who are not practicing in Gauteng, I'll give you a practical tip. Get hold of the practice manual for Gauteng, either the Pretoria one or the Johannesburg one. It is very useful for you to draft because it has all the notices, it has all the notices of motion, it has all the draft orders. It's very useful for an attorney or an advocate to have. And as you know, whatever happens in this province is ultimately then copied in the other provinces. So it's a very good idea to have it if you're not practicing in Gauteng. They're very useful. Now, with concise heads, these are the things you have to put in. And concise heads means no more than 2 pages. The issue, your main contention in respect of the issue, the authorities you rely on, and in this province, you have to also file a chronology document. Now, in all the other provinces outside of Gauteng, they don't use the continuing row. So in motion court, if it's an opposed motion, what happens is that you file your 3 sets of heads and you apply for a hearing date. You will be allocated a judge and you are guaranteed a hearing on that date. But before you get your date, you will have to file heads of argument. So outside of Gauteng, many of the provinces had a requirement for filing heads in opposed motions already. As far as trials go, there is no procedure that requires heads to be filed in a trial. But increasingly, and especially in lengthy or complex trials, a judge will request heads. A judge will say, maybe on the 3rd day, will say, I will require you to file heads. The judge will even give you time to prepare. You'll adjourn for a day to file heads. You'll come back the next day with your heads and present argument. Ideally, you should prepare heads before the trial and you run the trial according to your heads. That's the proper way of dealing with it. Now, these days, it's become a lot easier because of case management. In the past, the parties, plaintiff filed particulars of claim. They came out of the office precedent. or it was copied partly out of Ambler, partly out of the office precedent. The defendant filed a classic plea, bare denial, bare denial, bare denial. So when you're getting ready for trial, you read the pleadings, you don't know what the case is about. You don't know what the issues are. The pleadings are useless. That doesn't happen anymore, because what's happening now is that our courts are imposing a regime of trials-ready certification. What this means is you don't close pleadings and then go and do discovery and ask for a trial date. You have to go to a case conference. The case managing judge will read the pleadings. If it doesn't disclose any cause of action, and if the plea doesn't disclose any defense, the judge is not going to certify anything. The judge is going to say you can either go and amend these pleadings, or you can sit down and agree on what the triable issues are. Then you have to write it down. And here's the tricky part. Lawyers can always stand in a group or sit around a table and say, oh, of course, these are the tribal issues. Now comes the difficult part. Write it down. Put it on paper. Then they struggle. Well, these days, when you get trial certification, you would have dealt with things like identifying the issues, dealing with admissions of fact, dealing with admissions of documents, how many which witnesses are going to be called. All of that will be sorted out. So it's much easier for you now to write heads before the trial. In fact, the case manager will be helping you to write them. Okay, now let's talk about what is heads of argument. What is meant by this? I'm going to have to stop shortly because I need to look at your questions, but I'll go on for another 10 minutes. Argument means reason advanced. Okay, let's stop there. Reason. Reason is the key word. Your application of your logic, reason, for or against. Methodical reasoning. Again, methodical, logical. Heads require methodical thinking. It's what the courts expect. They do not mean you present large chunks of quotations from the evidence and authorities. It is not helpful. Now here's what the SCA requires. The SCA requires you to lodge your main heads of argument. Do you see, they don't say heads of argument. It's not written argument, it's main heads. There's a big difference. The operative words are main, heads, and argument. Now you'll see I've got Judge Harum's name there. Judge Harums wrote this in a judgment. He's also written a very useful article in the Advocate some years back on what is meant by main heads of argument. Main refers to the most important part of your argument, the substance of your argument, your main point, in other words. Heads means points, not a dissertation, okay? Main points. There's a reported decision. I think I may have given you the citation in your materials. It was a case where counsel wrote heads and did not present the main points, but basically wrote a dissertation on the point of law involved. It read like a textbook. Counsel was disallowed their fees because the heads were deemed to be useless. Okay. Argument involves a process of reasoning that must be set out in the heads. Now, you've heard me emphasize this from the start of this program. What does argument mean? It means a process of reasoning. Your heads of argument must demonstrate a process of reasoning. If that's not there, it ain't heads, okay? It's useless, it's not going to be persuasive, and it doesn't assist the judge. The rule requires the heads of argument, and these are the words taken from the rule: clear, succinct, and without unnecessary elaboration. Okay, I've dealt with that point. Now, what is argument? It is justifying your position with reference to the facts and law. Justifying involves a process of reasoning. Why is my position the correct one? Why do we say that the finding of fact must be my client's version, not my opponent's version? This has to be justified. Now, just to go back to the previous slide, what Haram says about main heads of argument was adopted in a number of SCA decisions. There they are on the screen. They're in your packs. Please read them. The failure to give attention to the requirements of the practice note and heads will result in disallowance of part of their fees. Now, here's something that didn't happen in the past. In the past, if there were punitive cost orders, it was usually the attorney who suffered. They were the ones who got the personal cost orders, de bonis propriis, and so on. Counsel got away with it. They never got penalized. Well, attorneys will be happy to hear that that has all changed, because now counsel get penalized with personal cost orders as well. And if you draft your heads in the SCA poorly, you don't comply with the Rule 10. In other words, you quote copiously from authorities and the record. You don't demonstrate any form of reasoning. Well, they'll simply declare your heads to have been useless, and you'll be disallowed all the costs, or worse, ordered to pay the costs. There's a decision, this one, Ensign Bigford versus AECI. This is what happens. The defendant's heads covered 115 pages. This is the judge talking. The first 55 consist of a dissertation on the defenses raised, the law, and a review of evidence of witnesses. None of this is related to any specific argument or contention. As far as the only point upon which the appeal has succeeded is concerned, there is, in this part of the heads, a reference to an authority and a two-line observation that the law on obviousness is trite and need not be repeated. I mean, this is hilarious stuff. These advocates were penalized. The heads of plaintiff consist of lengthy quotation and recital of facts, which are of no great assistance. Again, with little mention of any process of reasoning. So by now you get it. What I'm saying is heads of argument must demonstrate a process of reasoning. Absent a process of reasoning, it is not heads of argument. Now, there's the Caterham decision, which I would like you to read as well. I'm going to stop just for a short while because I want to go and see if there are any questions that I need to deal with, because this looks like a convenient spot for me to stop and carry on tomorrow, where I'll take you through the actual drafting of the heads. So just bear with me for a minute. Questions? Okay. 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 Okay, there's two questions here. Maybe you should post some questions. Oh, more questions. I will deal with those. Let me deal with the questions that I have currently. Regarding general drafting principles, what is meant by inappropriate words? Yeah, inappropriate doesn't mean swear words. It simply means that the word is too long, it is too complex. In fact, there is a simpler word that you could have used, and that we say is an appropriate word. An appropriate word is when you use plain language. Inappropriate word, bombastic language, big words, Latin, that's inappropriate. I've asked, okay, Mkolisi has asked, he would like to get some samples of what he could, of reading material. I will send a list of these books. By the way, these books are highly entertaining, but they all have one thing in common. They deal with logical reasoning. It's fun to read, but it starts developing your mind to think logically. Don't think that only mathematicians apply logic. Actually, they don't apply everyday logic. They apply the kind of logic nobody understands. Lawyers are the real experts at logic. You know, when you read good heads of argument, it's impressive because you can just see, it just clicks in your head as you read this thing and you think, okay, this makes sense. I get this point. I see the point. I'm persuaded. That's what happens. How would you, it's a question from Sinola, how would you go about structuring your heads of argument in preparation for a trial where there are two mutually destructive versions on the face of it? Right, this is a trial. So there is, the reason it's a trial is because there are two mutually destructive versions. I told you that when you are dealing with a trial, you have to be satisfied as to what your case concept is. In other words, what happened according to your client's version of the facts. You need to know that. That is what you draft in your heads as your material facts. Then it's not up to you to state your opponent's facts. What you have to do is sell your own facts. So your heads will be drafted, the facts will be dealt with in two broad sections. The one where you say, here are my material facts, and now say why it is the most probable version here. Why should the judge believe this version and not my opponent's version? So in that part, the first part, you will say, this is the material facts. It is supported by the undisputed facts. It is supported by credible witnesses. Now then you go to the second part where you deal with your opponent's facts. Show why on each material aspect, your opponent's facts are not likely to have happened. Now, sometimes in a trial, you'll have the luxury of having your opponent's witnesses destroyed in the witness box. Now, then it becomes easy. You can say the witnesses are unreliable. You can even call them liars. You can say that they cannot be believed and that there's only one credible version before the court. But you're not always so lucky, because in many cases, the witnesses on both sides can be equally impressive. So there's no basis for you to persuade a judge that the one is less credible than the other. How do you deal with it then? That's where you have to interrogate the probabilities of each element of that version. And you have to show that your client's version is more probable. Now, you don't have to show that the other side's version is improbable. What you have to show is that your client's version is more probable than the respondent's version or the defendant's version. And you do that with the reference to the facts as proved in court. How do you do that? By referencing the witnesses and saying why they were impressive. And I'll come to the part later where you interrogate a witness. How do you damage your opponent's evidence? So that seems to be the last questions. So I'm going to just carry on. I've got 15 more minutes. When you're drafting heads, I've split this into 3 stages. First stage, what is the context of your case? Contextualize the matter. In other words, is this civil or criminal? Is it contract or delict? It will help you to focus on the correct legal framework. That's what you do when you start drafting particulars of claim, where you first get the facts, then you contextualize, and then you start drafting. It's the same with the heads. You carry out an analysis of the issues and the evidence. That's your second part. And your third part, have a plan on how to present your argument. I will deal with each of those 3 in more detail. I was told, I just got a note. You are requested to post your question in the chat forum. You have 5, well, they're giving you 5 minutes. We're almost at the end of our time, so I'm not going to take any break. I'm going to carry on. So if you have a question, send it on the chat forum. Okay. Right. Before putting pen to paper, what do you need to do? Now, this is generally the technique. It doesn't matter if it's in a trial, opposed motion, or an appeal. Identify the factual issues. That is, those disputes of fact which are not agreed by your opponent and which must be proved for a successful outcome. In an appeal, there would have been a trial, and the judge either made an error of fact or did not make an error of fact. But we'll deal with that when we get to appeals. But you need to identify the factual issues first. Now, sometimes you'll be fortunate that you'll be going to court where the facts are agreed. You may have come across what is called a stated case, where the facts are agreed, but there's a dispute on the applicable law. So that makes it a bit easier. In which event you will identify the legal issues by applying the facts to the legal framework. Okay. If you haven't done this already, let's say you haven't issued summons in an action, you must identify at least a potential theory of the case or your case concept. You must know what happened. Now, this can go horribly wrong. I can tell you from experience. When lawyers don't spend enough time on the theory of the case or the case concept, it is like trying to find something in a dark room. You're going to be feeling around in the dark. You are going to stumble on things. You're going to embarrass yourself. How do you ensure that you don't get into trouble or embarrass yourself? It's very simple. Get the facts first. Don't worry about the law. That's the easy part. Get all the available facts. My advice is get the available facts before you issue the summons, because you are expected to plead the peculiar facts of your case in your particulars of claim. If you don't, in other words, you use the office precedent, a case manager is going to call you out. Look, our judges are experienced lawyers. You think they don't know that you used a precedent? I mean, I spent years on the bench, and I can tell you, every time I opened a court file and read the particulars of claim, I knew immediately if this came from a precedent. Okay, it just shouts out at you. So stop using precedents. Plead the peculiar facts of your case. You have to identify the gaps and ambiguities in the facts. Now, here's the thing. I don't know of any practitioner who actually got a perfect set of facts. That doesn't happen. Your own clients will lie to you, or they might have forgotten material facts, or they've now seen a document they had not seen before, and it's a very dynamic, fluid situation you find yourself in. Now, the thing about your case concept, between taking your first instructions and close of pleadings, you can afford to tweak it here and there, change it here and there, so that by the time you get to identifying the triable issue, you would know what your case concept is. In other words, you will know what happened according to your client's version of what happened. Now, let me give you an example of the ultimate embarrassment. This happens to us. We all hate it, but it happens because we were not careful with the facts. How many of you heard this question? Your client is in the witness box, your opponent is cross-examining, and your opponent says to your client, "Did you tell your attorney?" and comes up with a proposition of fact. You know what's happened. Your opponent has found a contradiction in his evidence in the pleadings or in the correspondence, and you did not clear it up before coming to trial. It is very difficult to come back from a question like that. Your client ends up becoming discredited. So be very careful about that. Don't take shortcuts. Now, how do you analyze the evidence? Now, this is also part of your developing your case concept. You need to know what are the undisputed facts. I would suggest that you write these down. Now, here's a good reason why you should. I told you judges may not know if the witness is telling the truth, but what a judge can certainly do is work out if that version is probable or not. How do judges work it out? The judges will say, okay, let me take the disputed part of his evidence and let me test it against a framework of the undisputed facts. So I will take the dispute. The dispute is who drove through a red robot, plaintiff or defendant. I will then take defendant's version, which is contradicted by the plaintiff. I have to work out which version to accept. The judge will say, let me take that version and look at it within the framework of all the undisputed facts and ask the simple question, is it supported by the undisputed facts? If not, why not? That will tell me if that version is more probable or less probable than the other side. Okay. So write down the undisputed facts. Write down the dispute. What are the disputed facts? What are the facts, disputed and undisputed, that support my version of the facts? There's nothing more powerful than to say to a judge, my lord, my client's version is supported by the defendant's own facts. That is the most powerful factual argument you can make. You have to establish proof of your facts. The facts must be justified by the evidence. Now, it's not within the scope of this course to take you through trial preparation, but those of you who do trial preparation would have come across something called a proof analysis. Now you need to do a proof analysis for heads as well. What is proof analysis? Proof analysis is where you look at your material facts and ask yourself, how do I present this to the court? I have to present it through a document. I have to present it through a witness. I have to present it through admissions of fact. Now you have to see if you can successfully do that. And the analysis will tell you that for this set of facts, you'll require witnesses A and B. You will require documents 4, 5, and 8 of the bundle. You will have that ready, okay? What is meant by a fact? Because remember, you have to provide proof of your facts. What is meant by fact within the context of a hearing in court? Fact means proof to the satisfaction of the court. If you cannot meet that standard, you have failed or you have not discharged the onus of proving those facts. Now, I'm going to deal with this aspect and then we're going to stop. I suppose to have given you a comfort break, but I didn't. I'm sure you survived. The layout. Now, before I explain the layout, I want you to notice something. You will notice the point first technique, context before detail. Now, this is a general layout for heads. We'll get more specific later. Start with a short introduction. Now, introductions must never be more than 10 lines. 10 lines maximum. You can do it in 5, all the better. Remember, in a trial, the judge is already steeped in the matter. The judge doesn't have to be told this is a dispute over the breach of a clause in a contract. Judge knows that already. All you want to do is give a brief background that suggests the nature of the matter. No more than that, under 10 lines. Now you have to state a short statement, give a short statement of the issues that require adjudication. The way to do this, have a heading that says the triable issues or the issues before the court and write them down. 1, 2, 3. 3 issues. Next paragraph, state what you want the court to find in respect of each of those issues. So you'll say the required outcome. So you got the issues, the required outcome. In respect of the first issue, the plaintiff or the appellant will ask the court to make the following findings. So you say what the answer is. Then the next paragraph, you make a short statement of the main points you will rely on. Without presenting argument, just say what your points are. And in this section, you can even state the cases you will rely on. Then thereafter, you will then present full argument point by point. What happens now is that in the preceding paragraph, you made a short statement of your main points. You take each main point, make a heading out of that main point, and then deal with it. Argument means you justify your position with the reference to the facts and the law. And then you conclude with the relief that you want. Now, if you cast your eye over these 6 points, you will see that it's a classic example of point first writing. You're first saying what the issue is, then you're saying what the answer is, then you're saying what your main points are to get to that answer, and then you present argument point by point. The judge follows it, and it works brilliantly. It's context before detail. Okay, tomorrow I will start with a trial, and then after that I'll move on to appeals. And it will require you to follow me, because I'm going to give you a step-by-step method, and I will number each step as step 1, step 2, step 3. Now you don't have to be too worried, because I've set out these various steps in the material that you've received. So I'm going to stop now. Those of you who still have some questions, you're welcome to send them through. I will deal with them tomorrow when we get together. Okay, rest well for the rest of the afternoon. Think about what we've dealt with. Might be a good idea for you to go and read the manual that I've given you on this part of the program. The first part on analytical thinking, there's no manual. This is stuff that I just wrote. But there is a manual on it, also written by me. It's in my book called Practical Drafting Skills. There's a chapter on analytical thinking. I would recommend that you read that. Tomorrow or after tomorrow, my coordinators will send you the details of my book, which deals with the entire drafting skills, from writing particulars of claim or pleadings, all the motion papers, all the the notices of motions and the 3 affidavits, as well as opinions and heads of argument. So I will give you those. We'll email those details for you at the end of tomorrow's session. Okay, thank you and goodbye for now.